Welcome back to the Making International in Korea video series. In this video, I'll be explaining to you one of the very sensitive issues in Korea in terms of international law, which is the North Korea's legal status in Korea. North Korea seems to fulfill four criteria for statehood stipulated in Article 1 of the Convention on Rights and Duties of States of 1933, commonly known as Montevideo Convention. Also, North Korea joined international organizations such as the United Nations, which confines its membership only to a state. As North Korea established diplomatic relations and concluded treaties with other states, it undoubtedly exists as a state under international law. However, domestic law of the Republic of Korea does not recognize North Korea as a state within the meaning of international law. The Korean Constitution stipulates in Article 3 that the territory of Republic of Korea shall consist of the whole Korean peninsula, thereby including North Korea. This provision reflects the legal position of South Korea that only one state exists on the Korean peninsula. From the perspective of South Korea, it succeeds its legitimacy as a state from the provisional government of Korea, and there exists only one state in the whole peninsula of Korea. Therefore, according to the Korean jurisprudence, no government organization that is in conflict with the sovereignty of the Republic of Korea shall be recognized. This is the manifest in the Supreme Court ruling September 28, 1961. From this perspective, North Korea is considered to be an anti-government organization or insurrection group. Several court cases confirm such a status of North Korea under Korean domestic law. This legal position that North Korea is merely an anti-government organization and the entire area of the North Korea belonging to Territorial Republic of Korea lead the following logical consequences. The first, while the law of the Republic of Korea obviously have the effect over North Korea, they are merely not applicable or executable at the moment. Second, the North Korea's aggression on June 25, 1950 is just a local riot, thereby leaving no room for law of war to be applied. And third, North Korean soldiers are not combatants of enemy state, so that they cannot be treated as prisoners of war. Rather, they should be punished in accordance with the domestic criminal law. And fourth, North Koreans are obviously people of Korea, so that who come to the South Korea are recognized as Korean nationals without the nationalization process. And fifth, the literary works created in North Korea are protected by the copyright law of the Republic of Korea. These are all confirmed by the court cases of the Republic of Korea. South Korea and North Korea, respectively, became a member state of the United Nations at the same time in September 1991. This fact raises a general legal question of whether the Republic of Korea recognizes North Korea as a state, because only a state is qualified to become a member of the United Nations. In addition, South Korea and North Korea signed the Agreement on Reconciliation, Non-Aggression, and Exchange and Cooperation between South and North, so-called Inter-Korean Basic Agreement, on December 13, 1999. As this agreement is similar with the treaty in terms of its formality, some argue that the agreement is legally binding as a treaty. If the Republic of Korea does not recognize North's capacity to conclude the treaty, an issue will arise as to whether such recognition is equivalent to the recognition of North Korea as a state. Since then, The two Koreas held the summit meeting and adopted joint communique along with the 4 agenda on economy. Furthermore, a great number of agreements were adopted between South and North, including the Inter-Korean Shipping Agreements of year 2004. The domestic court decisions of the Republic of Korea confirms that the simultaneously joining of the multilateral treaty, such as the UN Charter, does not mean the South's recognition on the status of the North as a state. It is also inferred from the court cases that agreements made between South and North are not treaties, but rather have a character equivalent of the communique or gentleman's agreement, having no effect on the legal definition on the status of North Korea as anti-government the organization as defined in Korean legal system. The Korean Constitution stipulates in Article 4 that the Republic of Korea shall seek unification and shall formulate and carry out a policy of peaceful unification based on the principles of freedom and democracy. Cooperation with North Korea is indispensable to peaceful unification. In Inter-Korean-based agreements of the 1991, the two Koreas define the South and North relations as not as one that is between the two nations, but rather as a special one that have been formulated during the process aiming at unification and pledged to jointly press ahead with achieving peaceful unification. Reflecting this situation, the recent decisions of the Supreme Courts or Constitutional Court of Korea recognize double status of North Korea, both as a partner for dialogue and cooperation for the peaceful unification of a country, as well as an anti-government organization aiming to subvert the Republic of Korea. Let me touch upon the sensitive issues, the two Koreas joining the UN and the issue of state succession. Both South and North Korea tried to join the United Nations for a long time, but it was not realized due to the vetoes by the Security Council member nations that supported South Korea and North Korea respectively. With the end of the Cold War, by the collapse of the Soviet Union, both South and North Koreas finally became member states at the same time of the UN on September 18, 1991. According to Article 4.1 of the UN Charter, it limited its members to peace-loving states. Thus, it raised the question of whether certain countries being a member of the United Nations means the collective recognition of a state by the UN member states. The Republic of Korea does not recognize North Korea as a state, but rather sees it as an anti-government organization under the Korean domestic law. Also, there are UN member states, including the United States and Japan, that do not recognize North Korea as a state. Conversely, North Korea does not recognize the Republic of Korea as a state either. Thus, the issue of status of a UN member state and recognition of a state were raised again by the simultaneously joining of the UN by both Koreas. With regard to this question, there is a view that, theoretically, joining the UN in fact recognition of states by all UN member states, for example, argued by the Hans Kelsen. However, the practice under the international law does not seem to be working in that way. In other words, recognition of state is a unilateral act of granting it by each state considering its own political situation, and so joining an international organization itself does not mean collective recognition of a state by all its member states unless there is a special reason for it. But in argument, the member state who voted in favor impliedly give recognition of a state unless their explicitly expressed reservation is being accepted as a convincing argument. And in fact, there are states that were recognized in that way. for example, Japan's votes in favor of Mongolia and the Kingdom of Bhutan to join the United Nations. The two Koreas joining was unanimously approved by all 159 UN member states at the time, without a vote at a general meeting of the United Nations, which means the United States and Japan did not specifically express opposition to the North joining and did not make a reservation on the matter of recognition of a state either. This can raise question of implied recognition of a state. However, it seems that the United States and Japan do not treat North Korea as a state, even after it joined the UN. In a sense, it is difficult to say that the United States or Japan recognized North Korea as a state by its UN membership. South Korea was not a member state to the United Nations at the time, and it did not have the opportunity to vote for or against it. Even after two Korea's UN membership, South Korea's consistent practice showed that it did not recognize North Korea as a state and vice versa.